The Supreme Court hands down judgment this morning in the case of the Public Prosecutor's Office of the Athens Court of Appeal, Appellant, against O'Connor, Respondent. This is a brief summary of the Court's reasoning. The appeal raises an important question of statutory interpretation as to whether to hold a person responsible for any failings on the part of their legal representative in giving notice within the permitted period of 7 days of an application for leave to appeal to the High Court against an extradition order. The answer depends on the correct interpretation of Section 26, subsection 5 of the Extradition Act 2003, which provides that if, as in this case, the notice of application for leave to appeal to the High Court was given after the end of the permitted period of 7 days, then the High Court must not for that reason refuse to entertain the application if the person did everything reasonably possible to ensure that the notice was given as soon as it could be given. The Divisional Court in England and Wales, in the case of Zegfu against Court of Pécs, Hungary, indicated that the correct interpretation of Section 26, subsection 5 permitted no distinction between the conduct of the person and the conduct of their legal representative. The legal representative's conduct was to be attributed to the person, with the consequence that if the legal representative had not done everything reasonably possible to ensure that the notice was given as soon as it could be given, the High Court should not entertain the application for leave to appeal against the extradition order. The issue as to interpretation arose again before the court in Northern Ireland, in this case, in which an extradition request was made by Greece in relation to Mr. O'Connor for the purposes of conducting a criminal prosecution against him. An order was made under which Mr. O'Connor was to be extradited to Greece. However, on the same day as the order was made, Mr. O'Connor instructed his solicitor to appeal to the High Court, and his solicitor stated publicly in court, in the presence of those representing Greece, that an appeal would be lodged against the extradition order. The solicitor lodged the notice with the court within the permitted 7-day period, but due to an oversight, the solicitor failed to serve the notice on those representing Greece until about 3 weeks later, which meant that the notice was not given within the 7-day permitted period. Mr. O'Connor had personally done nothing wrong, but if his solicitor's conduct was to be attributed to him, then he had not done everything reasonably possible to ensure that the notice was given as soon as it could be given, and the High Court should not entertain the appeal. The court in Northern Ireland, whilst conscious that they were interpreting a statutory provision applicable in the United Kingdom in a way which was in conflict with the view of the Divisional Court in England and Wales, held that there was nothing that required an interpretation that Mr. O'Connor's solicitor's conduct was to be attributed to him. The Divisional Court in Northern Ireland proceeded to entertain the appeal because Mr. O'Connor had personally done nothing wrong, but rather had done everything reasonably possible to ensure that the notice was given as soon as it could be given. The appellant appeals to the Supreme Court, contending that on the correct interpretation of Section 26, subsection 5, the legal representative's conduct was to be attributed to Mr. O'Connor. The Supreme Court unanimously dismisses the appeal for the reasons set out in a judgment given by myself, with which the other justices agree, which reasons I will now briefly summarize. In Section 26, subsection 1, the person is identified as the person who is subject to an extradition order. The word person appears twice in subsection 5. On both occurrences, it means the person subject to the extradition order. On the first occurrence, it is in the context of giving the notice. It is natural to assume that Mr. O'Connor can give the notice by means of his solicitor, because there is no reason why he should be required physically to lodge the notice in person rather than using an agent to do so on his behalf. Indeed, it would be impossible to deliver the notice personally if Mr. O'Connor was in prison. On the other hand, in the second occurrence of the word, the requirement of doing everything reasonably possible is imposed by the language of the provision only on the person, and there is no evident reason to understand it as also being imposed on the individual's agent or legal representative. This interpretation is supported by considering the vice which Parliament was addressing in enacting Section 26, subsection 5. The vice was the potential for substantial injustice being inflicted by the application of short and inflexible time limits. It was not the purpose of the legislation to perpetuate the potential injustice which would result from attributing the fault of Mr. O'Connor's solicitor to Mr. O'Connor. Accordingly, the court in this case was correct to depart from the interpretation of Section 26, subsection 5, indicated by the Divisional Court in England and Wales in Zegfu. The appeal must therefore be dismissed.